Okay, folks, I'm Carol Angela Davis reading the Mueller Report to you. Now, of course, this is volume 2 of the Mueller Report, and I'm going to read 2 pages a day, which is about 8 or 9 minutes a day, and today I'm reading pages 7 and 8. Okay, we're on overarching factual issues. We did not make a traditional prosecution decision about these facts, but the evidence we obtained supports several general statements about the president's conduct. Several features of the conduct we investigated distinguish it from typical obstruction of justice cases. First, the investigation concerned the president, and some of his actions, such as firing the FBI director, involved facially lawful acts within his Article II authority, which raises constitutional issues discussed below. At the same time, the president's position as head of the executive branch provided him with unique and powerful means of influencing official proceedings, subordinate officers, and potential witnesses, all of which is relevant to a potential obstruction of justice analysis. Second, unlike cases in which a subject engages in obstruction of justice to cover up a crime, the evidence we obtained did not establish that the president was involved in an underlying crime related to Russian election interference. Although the obstruction statutes do not require proof of such a crime, the absence of that evidence affects the analysis of the president's intent and requires consideration of other possible motives for his conduct. Third, many of the president's acts directed at witnesses, including discouragement of cooperation with the government and suggestions of possible future pardons, took place in public view. That circumstance is unusual, but no principle of law excludes public acts from reach of the obstruction laws. If the likely effect of the public act is to influence witnesses or alter their testimony, the harm to the justice system's integrity is the same. Okay? Although the series of events we investigated involved discrete acts, the overall pattern of the president's conduct towards the investigations can shed light on the nature of the president's acts and the inferences that can be drawn about his intent. In particular, the actions we investigated can be divided into 2 phases, reflecting a possible shift in the president's motives. The first phase covered the period from the president's first interactions with Comey through the president's firing of Comey. During that time, the president had been repeatedly told he was not personally under investigation. Soon after the firing of Comey and the appointment of the special counsel, however, the president became aware that his own conduct was being investigated in an obstruction of justice inquiry. At that point, the president engaged in a second phase of conduct involving public attacks on the investigation, non-public efforts to control it, and efforts in both public and private to encourage witnesses not to cooperate with the investigation. Judgments about the nature of the president's motives during each phase would be informed by the totality of the evidence. Next subsection title is called Statutory and Constitutional Defenses. Okay. The president's counsel raised the statutory and constitutional defenses to a possible obstruction of justice analysis of the conduct we investigated. We concluded that none of those legal defenses provided a basis for declining to investigate the facts. Next section, statutory defenses. Consistent with the precedent and the consistent with the precedent and the Department of Justice's general approach to interpreting obstruction statutes, we concluded that several statutes could apply here. Section 18 U.S. Code, and they go through the sections. One of them is Section 1512C2, is an omnibus obstruction of justice provision that covers a range of obstructive acts directed at pending or contemplated official proceedings. No principle of statutory construction justifies narrowing the provision to cover only conduct that impairs the integrity or availability of evidence. Sections 1503 and 1505 also offer broad protection against obstructive acts directed at pending grand jury, judicial, administrative, and congressional proceedings, and they are supplemented by a provision in Section 1512B aimed specifically at conduct intended to prevent or hinder the communication to law enforcement of information related to a federal crime. Next section, constitutional defenses. As for constitutional defenses arising from the president's status as the head of the executive branch, we recognize that the Department of Justice and the courts have not definitively resolved these issues. We therefore examine those issues through the framework established by the Supreme Court precedent governing separation of powers issues. The Department of Justice and the President's personal counsel have recognized that the President is subject to statutes that prohibit obstruction of justice by bribing a witness or suborning perjury because that conduct does not implicate his constitutional authority. With respect to whether the President can be found to have obstructed justice by exercising his powers under Article II of the Constitution, we concluded that Congress has authority to prohibit a President's corrupt use of his authority in order to protect the integrity of the administration of justice. Under applicable Supreme Court precedent, the Constitution does not categorically and permanently immunize a president for obstructing justice through the use of his Article II powers. The separation of powers doctrine authorizes Congress to protect official proceedings, including those of courts and grand juries, from corrupt, obstructive acts regardless of their source. We also concluded that any inroad on presidential authority that would occur from prohibiting corrupt acts does not undermine the President's ability to fulfill his constitutional mission. The term corruptly sets a demanding standard. It requires a concrete showing that a person acted with an intent to obtain an improper advantage for himself or someone else, inconsistent with official duty and the rights of others. A preclusion of corrupt official action does not diminish the President's ability to exercise his Article II powers. For example, the proper supervision of criminal law does not demand freedom for the President to act with a corrupt intention of shielding himself from criminal punishment, avoiding financial liability, or preventing personal embarrassment. To the contrary, a statute that prohibits official action under, oops, sorry folks, forgive me, sorry. Okay, be nice. I'll have to hold this. I don't know, it's being weird. All right. To the contrary, a statute that prohibits official action undertaken for such corrupt purposes furthers rather than hinders the impartial, even-handed administration of the law. It also aligns with the President's constitutional duty to faithfully execute the laws. Finally, we concluded that in the rare case in which a criminal investigation of the President's conduct is justified, inquiries to determine whether the President acted for a corrupt motive should not impermissibly chill his performance of his constitutionally assigned duties. The conclusion that Congress may apply the obstruction laws to the President's corrupt exercise of the powers of office accords with our constitutional system of checks and balances and the principle that no person is above the law. This is now the conclusion that I'll be reading. Because we determined not to make a traditional prosecutorial judgment, we did not draw ultimate conclusions about the President's conduct, okay? The evidence we obtained about the President's actions and intent presents difficult issues that would need to be resolved if we were making a traditional prosecutorial judgment. At the same time, if we had confidence after a thorough investigation of the facts that the President clearly did not commit obstruction of justice, we would so state. Based on the facts and the applicable legal standards, we are unable to reach that judgment. Accordingly, while this report does not conclude that the President committed a crime, it also does not exonerate him. That's pages 7 and 8. See you next time. That'll be tomorrow for 9 and 10. Have a good day.